It's Mike DelSignore. I'm outside the Waltham District Court, and I want to talk about what happens if you're charged with a third offense, OUI. It's going to be heard in this court. For a third offense, OUI, you should come to that court date with an attorney. The DA, in many cases, is going to ask for a dangerousness hearing to potentially hold you without bail for up to 120 days. Now, often I can have it denied, and the reason is that a dangerousness hearing requires that the government prove that no conditions of release will ensure the safety of the public. Now, in an OUI case, typically we can propose alternatives to incarceration, such as alcohol treatment, being alcohol-free, attending AAs. We'll show that your ties to the community, that you have family that's going to help you abide by these conditions, that you work, or basically pointing out everything in mitigation that we could. Any family connection, work, employment connections, if there aren't any, we'll show that, we'll let them know that you're going to be in treatment. I'll recommend treatment facilities for you. I've handled OUI cases for my entire career, so I know sometimes people who have OUI offenses have issues with alcohol, and I have contacts that I'll recommend to help you with that issue, because that's going to only help you in the court. Sometimes in an OUI offense, we may try to get the charge amended to have it reduced to a second offense, and that always requires evidence of sobriety, of alcohol treatment. When a charge is amended, it's not just the DAs in this court. They won't have the authorities to do that. It has to go up to the highest level in the district attorney's office for a reduction of a third offense to a second offense. But keep in mind, these are winnable cases at trial. The jury doesn't know that it's your third offense. So we fight the case the same way. We'll gather your medical records, ways to explain the driving violations other than alcohol. Is the road curved? Does it curve? You're familiar with the road? Were there potholes? So every little detail we'll look at to prepare your defense. As far as the field sobriety test goes, these tests are often inaccurate, unreliable, and there's a lot of reasons other than alcohol that can result in somebody not doing as well as they'd like to do on these tests. For example, you might have a bad back or knee issues. You can get your medical records to show to the jury that these medical conditions explain how you did on the field test. It wasn't alcohol, it was medical, it might have been fatigue. So we point out alternative explanations for the officer's observation and his opinion that he's going to say you're under the influence of alcohol. So that's what we want to do. That's what we'll bring as part of our defense. I'll prepare you to testify. In some cases, you'll testify. Not in all cases, but we'll always go over that. I want to make sure you understand what it is, what it means to testify, and have a realistic expectation of it. Because a lot of people, I think, fear testifying, thinking it's a big courtroom or a lot of people watching. This courtroom over here, the trial will be on the second floor. These trials aren't watched. They're not public. There'll be nobody in that courtroom. So sometimes people think that their friends, the whole community is going to be watching this. It's not like that. So it's important for you to understand what a trial is actually like. That way you can make a decision, because the last thing I want anyone to do, and that's what I'm here for, is to make any decisions based on fears or something that's really not a reality in terms of how the court operates. So third offense in Waltham or in any court in Massachusetts carries mandatory jail time. There's a few ways around that. As I mentioned, a reduction of the charge. Second way is if we can vacate one of the prior convictions, meaning we go back to the other court and find a legal reason why the conviction can't stand. And finally, if you go to trial, the government still has to prove those other offenses, so that from out of state, government may not have that evidence. Of course, the number one defense to a third offense is just to win the underlying OUI trial. If you win that trial, you're found not guilty, then you won't face any of the license consequences, and you could potentially get your license back if you refuse a breath test. So there's a lot at stake on a third offense OUI. You're looking at a mandatory 6 months jail, 150 days have to be served. I've handled these. You want somebody who you're confident in their trial abilities, that basically spends their entire career preparing cases for trial. And that's what we do. We're always preparing for trial. If you come to my office, I can show you different charts, graphics that we have to help convey your story to the jury. And we've done that for years. So I'd be glad to help you. You can call anytime. It's never too early, too late to call. My job is to help people in difficult situations. That's why I got into this business as an OUI lawyer, and I'm there for you when you need somebody to stand up for you when you can't speak. I'm going to make sure that your voice is heard If there are any legal issues in the case, such as motions, we'll do those motions to make sure there's a basis to stop you, that your statements are properly admissible into evidence. So I'd like to explain your defenses to you to make sure you understand everything and give you all the best information to make the best decision for your case. That's ultimately what I want. I'm here to help you whenever you need it. Feel free to contact me. 781-686-5924 is my personal cell.